The college admissions scam, also known as Operation Varsity Blues, has made U.S. headlines. Beyond the Department of Justice's criminal charges, students have filed a class action lawsuit against many universities for racketeering, negligence, and two separate types of consumer protection violations: deceptive trade practices and unfair competition. Let's discuss the consumer protection violations. First, deceptive trade practices. The California Consumers Legal Remedies Act, or the CLRA, as does Georgia's Fair Business Practices Act and a number of other states' consumer protection acts, prohibit a seller of goods or services from representing that goods or services have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities that they do not have, or that a person has sponsorship, approval, status, affiliation, or connection that he or she does not have. According to the students, each of the universities listed in the complaint violated this portion of the CLRA because their websites state that admissions are based solely upon the student's merit, when in fact, each of the admissions processes at these universities have been tainted by corruption, such that those parents with children who had mediocre grades and test scores were allowed admission based upon the amount of bribery money that they paid to university insiders. The students claim that they were damaged because they paid application fees based upon the university's representations that their application processes were fair, neutral, and based on the applicant's merit. Next, unfair competition. The California Unfair Competition Law, or UCL, restricts people and/or companies from engaging in unfair competition. It defines unfair competition as a business act or practice that is unlawful, unfair, or fraudulent. Unfair, deceptive, untrue, or misleading advertising, or false advertising as prohibited by California Business and Professions Code. These definitions are disjunctive, meaning that a practice may be prohibited as unfair or fraudulent, even if it's not unlawful. The students claim that the university's conduct in representing that their application processes are based on merit, while simultaneously turning a blind eye to the bribery of prominent university employees, constitutes a violation of the UCL because it is within the initial 4 definitions of unfair competition. The students further allege that the failure of each university to have audits or other quality control mechanisms in place to ensure this behavior did not occur is in itself an unfair business practice. This lawsuit serves as a reminder that businesses and other institutions cannot hold themselves out as being or doing one thing, while in truth doing something very different. Those who do may find themselves the subject of a variety of legal issues, including consumer protection claims. For more information on this subject, see my blog at bfvlaw.com. And as always, let me know if I can help.